Hello, everybody. I hope everyone can hear me. I am Colleen Sweeney, and I'm going to take you through the form changes. We do have quite a few people joining this webinar, so what we're going to do right now is just give it another minute, so everyone can kind of populate it. It's, you know, how technology is, it's not magic. I did also want to start and just let you guys know, because we have so many people on this presentation, I'm not going to be able to take questions. However, like I always do, I will read the chat, and I will get back to you with any questions. And also my email, my cell phone number are there. If you have questions for me moving forward, feel free to reach out to me. What I try to do with these presentations are definitely take the time to anticipate questions. I actually attended the presentation at NVAR today to hear questions, so I could include the answers in here already. So I'm hoping that I'm anticipating your questions and answering them. But also here's a resource for you, both for the forms changes and also for settlements. So feel free also to send me your contracts at my email there. Um, Okay, I'm going to go ahead and get started. Again, I'm Colleen Sweeney to give you guys a little bit of information. I am on the forms committee, so one of the things I try to do when I present these forms is kind of give you an explanation of why the forms changed. So we're going to start and know that we're here for January 1st, 2026 is when these forms go into effect. And I really commend you guys for being here now, because a lot of people aren't looking at them till they populate in their forms, wherever they get their forms, whatever provider. And that becomes really problematic because, you know, you may not know what the changes are. So I'm going to start because when I went to look at the changes, they're a little bit different. Now, this is if you're viewing them online, as not as opposed to the app, you can actually see them in the app as well. But so how do you see the changes now before they're actually in your form provided list? So NVAR has updated the website. You're going to have to log into your account to see the form changes. All right. The NVAR standard forms revision is going to be accessed by clicking on the banner at the top of the page as you log in. And then you can click on it and you're going to see this page come up. And so one of the things I always like to remind people is not only can you look at the standard forms changes for this update, but the past iterations are as well. I've always found this to be really helpful. So once you get to this, you're going to click on January 1st, 2026 standard forms changes. You'll be able to look at it. And once you click on it and you want to see the form in its actual what it's going to look like as of January 1st, you can just, it's a hyperlink. So you just are going to click on it right there, and then the form comes up. It's going to say educational version. That's how you know it's the form that's going to come into the forms provider as of January 1st. And again, it's a great idea to just get a look at these before they auto-populate. That being said, I'm going to walk you through all of them. And so let's talk about it. First, we're going to say, why did the forms change? For those of you who have joined my presentations before, you've heard this, but it's really important information for everyone to understand. So each year the law changes. That's usually July 1st, and the forms are updated to comply with the legal requirements. And then changes are made every 6 months or as needed to clarify and improve the form. So generally we see those changes twice a year. All right, so what drives the changes? The legal hotline. And one of the reasons I really like to tell people this about the legal hotline is because you all can be part of this process. The Standard Forms Committee is going to hear that hotline report. When we see the same questions over and over, we know that that's a good idea, that we need to start looking at that information. All right, the NVAR board ultimately approves the final revisions, so they make these decisions. And again, the law changes, and when the law changes, they have to be legally compliant. So, important thing for you guys to know, you're part of the NVAR community, and you can influence the changes by calling the hotline to address the areas in the forms that cause confusion. Just so everyone knows, their NVAR has hired a new attorney, but throughout the process, somebody was actually getting their calls answered. So there was an attorney answering those calls. All right, so here's the roadmap. I always like to give the roadmap of what we're going to be looking at today. The changes are the residential sales contract, the conventional financing contingency, the VA financing contingency, FHA, and USDA. All of these financing contingencies are going to have the same changes in them, so don't get too overwhelmed by that. 1331, a notice to remove the financing contingency. We're going to review that. There's a new form, which is a sale of property subject to lease addendum. This is a really good one we're going to talk through. The lead-based paint disclosure for both sale and rental. The optional listing information sheet. The exclusive right to represent the buyer agreement. And there's two administrative changes, the buyer pre-settlement occupancy addendum and the inspection contingency removal addendum. All right, so let's start with the good news. The changes to the residential sales contract are important. I want you to be paying attention, but I want you to know they're not going to change, substantially change how you conduct your business, okay? And that's important for you guys to know. I know there's a lot of things getting thrown at you. Oops. Sorry, technology problem here. There we go. So 3 paragraphs contained updates in the residential sales contract. They're going to be paragraph 9, which is property maintenance and conditions and inspections, paragraph 27, definitions, and then paragraph 33, additions. So we're going to walk through these paragraph by paragraph. So the first one we're going to see is the paragraph 9, the property maintenance and conditions and inspections. So the change is this. The last sentence in property maintenance and condition inspections paragraph was updated to state, the buyer will conduct the final walkthrough within 7 days prior to settlement or occupancy, whichever occurs first. So what does this actually look like? Well, the contract from the old paragraph 9 from the July of 25 version looked like this. And now it's going to have this, what I've highlighted there is what's been really, or occupancy, whichever first occurs. So why was this change? This is to take into account the pre-settlement occupancy situations. It doesn't happen that often, but it was just, it just came to our attention that in fact that wasn't very clear. The board wanted to make sure that this clarification was in there. So small change there. I don't think it's going to have a big impact on your practice. Okay, so definitions, paragraph 27 in the residential sales contract, the added clarification and definitions paragraph, that ratification can occur anytime between 12 and 11:59 at night on the delivery date, and define the documents, notice voiding contract and notice removing financing contingency. We're going to get to this important change, but we're going to go through it step by step. So we're going to start here with a pretty easy one, the ratification, okay? And now we've added that for purposes of determining the date of ratification, ratification can occur anytime between 12 a.m. and 11:59 on the delivery date. The why here was this clarification was made to address a frequent misconception that if ratification occurred after 9, the ratification date was the following day. I think that confusion came up when people were seeing with other parts of the contract where was that 9 o'clock. So to be clear, the date that the contract is ratified as defined in 27A is the ratification date. This date represents day 0, no matter what time of day it was ratified. Day 1 is the day after the delivery, okay? So this is important, obviously, in counting days for contingencies, all sorts of things, but just a clarification because it happens so often that people were confused if it happened after 9 o'clock that wasn't the date of ratification. All right, so this one is the new definition in paragraph 27. Notice voiding contracts, it means NVAR form K1367 entitled Notice Voiding Contract. Notice Removing Financing Contingency means NVAR form K1331 entitled Notice Removing Financing Contingency. So let me talk you through some practice pointers here. Pursuant to the term of this definition, it is now a requirement that if you are unilaterally voiding the contract, you're going to have to use NVAR Form K1367, Notice Voiding Contract. Unilaterally removing the financing contingency, you're going to have to use Form K1331, okay, which is the notice removing the financing contingency. Why? We're trying to address what happens when a lender delivers directly to the listing agent the lender rejection letter. That is not proper delivery, and it needs to be a two-part step. And that's really important to understand. There's more to follow on this change, but this is just, it arises in the definition, so we wanted to start there. All right, so another change in the additions paragraph, this is paragraph 33, we removed the extension of HOA condo review period document and added the sale of property subject to lease addendum to the additions paragraph. This is a new form. We're going to get to that one. But so what does this look like? The old paragraph, y'all were very familiar with, always checking those boxes. That's the old paragraph. What is highlighted in red is no longer going to be in there. And what is going to be in there is that what is highlighted in yellow is the sale of property subject to lease addendum. So if you're using that, you would want to include that by checking that box in that paragraph. The reason for this is we removed the extension of the HOA condo review period because this is negotiable within the contract and an extension would be after ratification. So it didn't make sense for it to be in there. All right, and added the sale of property subject to lease addendum. Stay tuned, that's going to be a new one, which I'm going to walk you through. All right, so that's the good news. Those are the changes as it relates to the residential sales contract. Again, I don't think this is going to have a substantial impact, but it's a great way that the board is determined to make sure that these are tweaked and work in all the different situations, or at least as many as possible. So now we're going to get to all the financing contingencies and some changes there. There's really two changes related to the financing contingencies that are the same in all four forms. Number one, that added the language that the buyer must deliver notice voiding contract, K1367, with a denial letter, and added language that the buyer must deliver the notice removing the financing contingency, K1331, with either the commitment letter or evidence that the funds are available to close without financing in order to remove the contingency. I gave you a little bit of background about why that was, but this is important to keep in mind. These changes are consistent now with the definitions we've already reviewed in the residential sales contract. But a step-by-step process, I think, is helpful. This is the old paragraph 2 from the July 23 changes, which is the last time that form was changed. And here's the new one. And you see that it's going to now say how you do this. You deliver to seller a notice voiding the contract as defined in the contract and a written rejection letter from the lender. Okay, so think of this as two distinct requirements. Number one, the notice voiding the contract, K1367, and a written rejection letter. And I'm emphasizing and because both things are going to be required, okay? All right, so next paragraph is the financing contingency with automatic extension, okay? We're gonna see again what is required, that notice voiding contract and the lender rejection letter. And you're going to see that consistent throughout there. I've highlighted all of the changes just so you can see them, but it's pretty consistent with what I'm telling you, or it is consistent with what I'm telling you. So again, to void, the buyer must provide a notice voiding the contract and the lender rejection letter. Contingency can also be satisfied, okay, by notice removing the financing contingency and the written loan commitment of specified financing, or evidence of availability of funds to settle without financing, okay? That is the two ways that that can be addressed. I think broken down like this, not to beat a dead horse, but it's really important if you start thinking of this as a two-step process, it will be very helpful for you. All right. The financing, old paragraph 3B, and again, these references are to the conventional financing. Um, and now I'll show you again how this has changed. Again, under buyer may void the contract by delivering seller a notice voiding the contract and the lender rejection letter. It was only before the lender rejection letter, all right? And they may satisfy the contingency by delivering a seller a notice removing financing and loan commitment or evidence of the availability of funds necessary to settle without such financing. Okay? So again, this is the process that you're going to have to take, that's going to have to take place. This is important for you guys to understand and take these steps. Now, there has come sometimes where a lender is providing that letter directly. That's not proper. So keep in mind, you want to carefully outline both of these steps and make sure you're protecting your clients on these. All right, so the conventional financing contingency, NVAR asked me to address this because there's a lot of confusion as it relates to this. And I can tell you the Standard Forms Committee spent a lot of time on this. It's complicated. Part of the reason this is complicated is because lenders are not parties to the contract, and lender rejection letters are something that are required. So I want to just point out that this is something that is often explained to buyers in a way that is not accurate. So remember, in paragraph 1 of the specified financing, the interest rate for this loan is at an initial interest rate not to exceed blank % per year. And so I'm going to give you some practice pointers here. Fill in the interest rate. Do not say the market rate, okay? Remember, the buyer is required to get a lender rejection letter to utilize this contingency. There needs to be some parameters there, all right? If your client applies for a loan at a higher rate than stated, or a lower rate than stated, or just a higher rate than stated, it puts them in an alternative financing. And this is why this is important and something that people don't often understand. Remember, with alternative financing, the financing contingency will not apply to any alternative financing. Alternative financing is defined as any change to the financing terms in the specified financing included, and see what I have highlighted there? Interest rate. So you're locked in to that interest rate, and it's really important to understand the ramifications of this. This is not a change. It's just something that we were trying to provide some further clarity on so that people understand how this works. So important things. I think hopefully this will be a little bit of education that goes a long way this year. Okay, so the notice removing the financing contingency. This form was added back into the NVAR library with updated language, which is consistent with the financing updates that we've been talking about. That's what this now is going to look like. Okay, this is the form. In accordance with the financing contingency paragraphs, as all stated, the buyer is hereby removing the financing contingency and attaching one of the following documents. All right, the loan commitment or evidence of the availability of funds necessary to settle without such financing is attached. Okay, keep in mind now you have to use this form. It's back in the forms library, and so it's available to you. All right, so here's a new form. This one is to be used when there's a current lease in place and the buyer will take as the landlord at the settlement. Okay, important things to consider here. This is an addendum, not a contingency, okay? Be sure the buyer has received a copy of the lease, reviewed the terms of the lease, understands the ramifications of the lease, is not purchasing this as their primary residence if the lease is longer than 60 days after settlement. Why am I telling you all of this? Because it's not a contingency. If they have a copy of the lease, and they don't have a way to get out of it. If they don't have a copy of the lease and they're going to get it afterwards, I don't know what good it does them if they can't get out of it. So keep this in mind. It's really important. If the lease hasn't been reviewed by the buyer, consider writing a contingency to allow for a time to review the lease. Just make sure that you understand that once they get the lease, as written, they can't get out of the contract. All right, I love this addendum. I think it's going to be really helpful to y'all. So let's start with just breaking it down. Paragraph 1, the lease terms, obviously the initial information is in there about the buyer, the seller. But the lease terms, paragraph 1, it's going to be an acknowledgement of the lease, the end date, the rent, if the renter is current on their rent, really critical information that people who are going to be buying this house subject to the lease are going to need. And it's going to have to say what the security deposit is, okay? Because that's going to have to be transferred. A copy of the lease. Statement that if the lease has not been provided, it will be within 2 days of execution of the addendum. Again, a lot of information in that lease. I would be reluctant if they haven't seen the lease. But people want to do it. That's why it's written that way. Paragraph 3, contract provisions, modifications, all right? Property maintenance, condition, and inspection. Obviously, we have to delete the requirement for the property to be delivered free and clear of debris and broom clean because there's a tenant in it, right? Reasonable access is now defined to include consideration of tenant's schedule and quiet enjoyment of the property. It's important because there's a tenant. And it's a note that the seller is responsible for coordinating with the tenant to facilitate access. All right. Possession date, seller will transfer possession to the buyer, but it will be non-exclusive, subject to the rights of the tenant. And at settlement, the buyer is responsible for the performance of all landlord obligations. Okay, so that's the first page. Now going on to the second page, we see the paragraph 4, which is the seller obligations. Provide written notice to the tenant of the sale of the property to the buyer. Obviously, they need to do that. It's important, and that they are the seller is the person in the position to do that. Provide notice to the property manager, if there is any, about the sale. Provide the tenant written notice of new location of the security deposit. This might be a requirement of the lease, and there's parts of the law, so lots of things have to be carefully coordinated there. And transfer prorated rent as the settlement date and the security deposit to the buyer, because at the end of the lease, the tenant is going to be looking for their security deposit, and that needs to be addressed. Keep in mind the seller will remain responsible for all obligations of the lease and the VRLTA requirements through settlement. Seller is not permitted to make any modifications, amendments, extensions, renewals to the lease without written agreement of the buyer. You certainly wouldn't want the seller to say, oh, you can live rent free for the rest of the time, and that's an amendment that would be made, and the buyer would have no understanding. So this is important protection in there as well. All right, the assignment of the lease is in paragraph 5. Seller assigns all rights as allowed, and buyer accepts and agrees to be substituted in place of seller and as the landlord. This is going to require both the seller and the buyer to sign. All right. Note again, if you're using this addendum, paragraph 33, the additions paragraph in the residential sales contract, you should note that. All right. So this came up in some discussions, and I just want to say, I would not suggest using this form if there's a tenant but no lease in place. At that point, as you all as agents, I would suggest that you would be reminding people the potential buyer that they would need to seek outside counsel in terms of the ramifications of that. So this is really meant to be used in a situation where the seller is selling the property, there is a tenant in the property, and there is a lease in place, okay? And I would hope that that lease would be reviewed prior to making an offer on the property. All right, so lead-based paint disclosure for the sale is K1034, and lead-based paint disclosure for rental is 1035. Section C, this was added as an option for the purchaser to acknowledge that the seller has no information, knowledge, reports, or records pertaining to lead-based paint and/or lead-based paint hazards in the home. This language is now consistent with the existing options for sellers. So you'll see now it has the purchaser has, and you have to check one below, and then the new language has been advised that the seller has no knowledge, information, reports, or records pertaining to lead-based paint and/or lead-based paint hazards in the housing. All right. Section F was updated selling sales associate to buyer sales associate in initial and signature lines also. So just the buyer, I just highlighted what it was in section F, but as you know, it's going to be in the signature lines as well. All right, so optional information listing sheet. There's prefatory language in there. As I said, I was just at NVAR and they were doing a presentation, and I think more and more people are beginning to use this form. It was modified to add information about where to send an offer, the email, the name, and also to whom. It was modified to be consistent with the residential sales contract, that's the Y. And here's what it looks like now. Again, the information that I've highlighted in yellow is the new information, not really substantive, but again, it makes it more consistent throughout the forms. Okay, the optional information listing to keep this form consistent with the residential sales contract. It was modified to state condo association and co-op association. The prior form had the words sent out, spelled out, just again, consistent. I've highlighted there what now says condo, previously said condominium, and the co-op, and that's just been shortened again, just for consistency. All right, the exclusive right to represent the buyer agreement. So here's a change in paragraph 8A we want to focus on. The blank line was removed in options for compensation type, and the following language was added. Okay, and it's going to be a blank percentage of gross sales price plus a dollar amount to be filled in. All right, the previous form was compliant with the NAR settlement. However, how it was being used was problematic, and this was just a proactive step by NVAR to get on top of this. All right. Remember the requirements of the NAR settlement related to compensation, lots of them, but keep in mind the amounts must be clearly defined and readily ascertainable. Again, this is some things that was problematic when people write language themselves sometimes. And so the goal here was just not to have that situation arise. So the 1338 exclusive right to represent buyer agreement compensation. Here's the old language and here's the new language. Again, what I have there is highlighted the amount of broker compensation, check one, and they now all say or, okay, and the other was removed. So in the event, this is just a practice pointer, in the event that you have a situation where the compensation cannot be documented with the options on this form, the new form, okay? It doesn't mean you can't do anything about it. It's just you want to speak with your broker. It's a hot topic. You want to make sure you're compliant with the NAR settlement. Speak with your broker and document on the brokerage representation agreement addendum K0004 how you're going to do that. But this is really just, again, being very careful, making sure that everybody's complying with the terms, and before you fill in a form, you understand the ramifications of the form. All right, so what does this look like? Just the whole form here. Practice pointer number 2, if you or your brokerage charge a fee in addition to the compensation, example, transaction fee, that should be documented in paragraph 8C entitled broker service fee. That's where that belongs. I just don't want anyone to be confused that the third checkbox requires that transaction fee go in there where that dollar sign is. Okay, so be careful not to include the transaction fee again in paragraph 8A and or forget to include the transaction fee in paragraph 8C. All right. All right, we have 2 more changes. They're quite straightforward. It's the buyer pre-settlement occupancy addendum. Paragraph 3, property maintenance and condition, change the walkthrough inspection to final walkthrough, again, for the consistency with the July 1st, 2025 form changes. All right. I think the easiest way for me to kind of point that out to you is just give you guys this in a red line version. So what's stricken through is walkthrough inspection, now says final walkthroughs, and again, that happens twice in paragraph 3. So there's important information for you guys there to see, but it's pretty straightforward. Again, it was an administrative change. All right, and then the second administrative change is inspection contingency removal addendum, and then you can obviously fill in whatever number. Paragraph 2, the paragraph was modified to remove the word inspection and replaced with walkthrough to be consistent again with the residential sales contract. And so I've just, again, towards the bottom, third line up, you'll see what it has, it's a red line version there. So inspections was struck through and final walkthrough was added. All right, so that's all of the changes. I don't think that anything here is going to be too substantive. It's not going to create a lot of changes to your practice, but one thing that's really important, again, is just understanding them. We at MBH are always here to help you with your education. We have the monthly CEs, and we're here as the forms change as well. Feel free to call me on my cell phone number there or email me with any questions. We thank you so much for joining. I know that it's always hard to get used to the new forms, but hopefully walking through them in this process helps you guys. So thank you, and we look forward to working with you.